Good day, Crime Talk aficionados. We have a great show for you. First, Donna Adelson finds out that lockup is kind of a tough place. Well, who called it? Karen Reed is denied by the Massachusetts Supreme Court. A Colorado teacher is accused of doing some inappropriate things with a bit of a twist. We have this day in legal history and our dumb criminal of the day. And we have our unboxing of the Battle Box. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Now, also, need you to go to CrimeTalkSearch.com. Sign up for that background subscription service today so that you can do a background search on anyone here in the United States. And while you have that subscription, which you can cancel at any time, you can do one search or you could do 1,000 searches. And a report is literally emailed to you moments after you complete the questionnaire that they ask you to do. It takes just minutes. In that report, you're going to get all kinds of information to find out if somebody has a criminal history, their social media presence. Do they own property? Do they have debts? Do they have judgments against them? Are they married? Are they divorced? Go to CrimeTalkSearch.com. Find out today. Ladies and gentlemen, knowledge is power. And who knows? It could save your life or the life of a loved one. Check out that person that's coming into your life. All right, let's go ahead and open the record for February 11th, 2025. And first on the docket, that's right, Miss Adelson. Donna Adelson is finding out lockup can be a tough place. Well, her attorneys are pushing for her to be released from jail as she awaits trial, claiming that she is being threatened and extorted by other inmates. Welcome to prison. Welcome to county jail before you go to prison. Anyway, the Leon County Sheriff's Office confirmed last week that Miss Adelson had been placed into protective custody after she claimed she was assaulted in a jail bathroom. Now, the sheriff's spokesperson said that the alleged incident happened back in December, but was not reported to the sheriff until this week, and the sheriff's office is now investigating. Now, Miss Adelson's motion to be released on bond includes claims that she is not receiving adequate medical care and has been repeatedly threatened and abused by other inmates while in jail. The motion details the alleged incident in December in which Adelson claims an inmate shoved her face into her bunk, and when Adelson asked why the woman had done that, the other inmate responded, "Because you are an bleepin' killer." It also claims an inmate yanked Adelson's arm behind her back as she brushed her teeth back in October and demanded that she start buying her food and snacks from the jail canteen each week. Now, the motion also alleges that Adelson has since purchased more than $1,000 worth of canteen items for that inmate because she was scared for her life. Oh, and now it's all come out and they're investigating. And now it's really going to get rough for Miss Adelson because now she's a little snitch. That's the way the inmates are going to take a look at it. Anyway, the motion goes on to describe an incident in the shower in which another inmate touched Miss Adelson inappropriately. Defense attorneys are asking the judge to set a bond in this case, saying that Miss Adelson is not a threat to the community or a flight risk. Now, I'm sure the prosecutor is going to bring up the fact that Miss Adelson was arrested on the plane headed to Vietnam. I think the DA is going to mention that. Anyway, and her husband would also move to Tallahassee to stay with her pending trial if she is released. Now, the defense is suggesting that she be placed on an electronic monitor between 7 p.m. and 7 a.m. and have a curfew with no travel outside of the county. Now, as you may recall, Miss Adelson is accused of conspiracy and murder in the death of her former son-in-law, Dan Markle, and he was gunned down as he pulled into the garage at his home back in July of 2014. And Miss Adelson is the fifth person arrested for the murder for hire plot. 4 others, including her son, Charlie Adelson, are already serving time in prison for the murder. Adelson's attorney also filed a motion to suppress on Friday, hoping to keep a recording of a jail phone call with her just convicted son, Charlie Adelson, out of court. That motion will be denied. You have no expectation of privacy when you are in jail. That's when Charlie was in jail. But the phone calls tell you repeatedly that they're being recorded. That motion will be denied. Anyway, court records indicate that on November 7th, the call was discussing getting things in order and fleeing to a non-extradition country. That's that whole flight risk thing. consciousness of guilt, ladies and gentlemen, right? Why are you running away if everything's fine? Anyway, Adelson's defense team contends that the jail phone call dropped at the 8-minute mark, and anything recorded on the open line after that is not admissible in court. The question here is whether the consent given when the call comes in, well, whether that terminates when the inmate side of the call ends. That's what the defense attorneys are arguing about. I think the court's going to find that even if the call drops on the inmate side, but it's still recording the person on the outside, Miss Adelson, well, I think she still consented to the call. We'll see what the judge goes with, but I'm not aware of any case law that says that somehow then it should be suppressed. I'm not aware of any case law. Anyway, the judge in this particular case, a Stephen Everett, has set a 3-hour hearing on February 26 to hear those arguments and also consider the bond argument along with the motion to suppress. Adelson is expected in court for a status hearing on Tuesday, assuming she makes it that long. And yes, the Karen Reed case. I get it. We're giving Karen Reed the presumption of innocence, and I probably would have voted not guilty based upon the original trial. But I've said all along that her idea that somehow she was entitled to this not guilty verdict on the counts that were never recorded in open court, I didn't think she was going to prevail. And guess what? I was right. Not trying to say I told you so, but just trying to be realistic here. When the court did not take the not guilties in open court, jeopardy had not attached. And to say otherwise, I think, is a little intellectually dishonest. In this particular case, Miss Reed wanted her cake and eat it too, which was declare a mistrial, judge, declare a mistrial. And the jury in this particular case somewhat misled everybody by saying they were deadlocked on all. It made it sound like on all counts. What did you expect? Anyway, so Karen Reed is going to face all of the same charges, including the second-degree murder, when she stands trial for the second time this spring after the Massachusetts Supreme Court, the highest court, denied her bid to toss those charges. Now, for those who aren't familiar with the case, prosecutors have accused Miss Reed of running down her boyfriend, now former police officer John O'Keefe, with her SUV and leaving him to die in the cold and snow outside of a friend's home. Now, Miss Reed has maintained her innocence, and her defense has alleged a wide-ranging cover-up at the hands of the investigators and the owners of the home where O'Keefe's body was ultimately found in the morning. Now, Reed's first trial ended in a mistrial after jurors reported they were hopelessly deadlocked. And in the days after the trial, Reed's defense attorney filed a motion saying the jurors had contacted them to say no. In fact, they had been unanimous that Reed had been not guilty on the second-degree murder, and the panel was only split on the lesser charges. So, in their appearance before the Massachusetts High Court, Reed's attorneys argued that retrying Reed on the murder charges would amount to double jeopardy. Her defense attorney said they were contacted by 5 jurors after the trial and argued that the affidavit from the jurors reflect a clear and unambiguous decision that Miss Reed is not guilty on those charges. Now, prosecutors argued that the jury's notes stated that it was deadlocked 3 times and never indicated that it had reached a unanimous ruling on any charge. And guess what? The prosecutor, the defense attorney, nor the judge ever asked if they had reached a decision on any of the charges. So the Commonwealth conceded that it too had been contacted by jurors who said that the jury had voted not guilty on at least one count. But in its decision, the Supreme Court found that there was no abuse of discretion of Judge Cannon's decision to declare a mistrial. The court also found that the jury's third and final note implied that they were deadlocked on all of the charges, not just some. Gee, if we go back and look at those videos that Scott put up, I know it's going to be that this is what I said. Vindicated. And like I said, I would have voted her not guilty after the first trial. It was a complete screw up on the prosecution's part. And now they're going to come back and they're going to fix the charges. They're going to fix the trial. They got an experienced prosecutor this time. Look out. Anyway, that note, the one that said we're deadlocked, it reads as follows. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. Now, the justices also found that had Judge Cannon inquired whether the jury had reached a partial verdict, Reed would have standing to argue that any verdict was the result of some sort of coercive intrusion on the jury's abilities to do their job. But they didn't. Anyway, retrial is set to begin on April 1st. Her attorneys have indicated that they plan to file another motion to dismiss the case in its entirety, and a hearing on that motion is scheduled for March based upon discovery violations. That probably has more play than this argument did, whether it was in the trial court or in the Supreme Court, obviously, because they said no. Somebody, the prosecutors, the defense attorneys, or the judge could have asked, have you reached a decision on any count so that we can take a verdict on those? But they didn't. And so since they all failed to do it, basically the court says, a pox on all your houses, go do the trial again. Next, a Colorado teacher doing inappropriate things with a little bit of a twist. That's right. This teacher who started a relationship with a special needs student. That's right. A special needs student sent thousands of messages to him, ordered the child to bring a gun to class to shoot her colleague, and introduced him to fentanyl. Nice lady. Anyway, Miss Kay Ewer, a paraprofessional, was busted after officials noticed her favoritism towards the 16-year-old boy, according to the district attorney's office. Now, Miss Ewer showed an unhealthy interest in her student that was noticed almost immediately after she started working at the Brady Exploration School back in August of 2023. Then in November of 2023, after the boy hinted at an improper relationship with Miss Ewer in a classroom assignment that another teacher saw, police began an investigation. They soon uncovered evidence of a disturbing sexual relationship between the paraprofessional and the student, including explicit text messages and signs that drugs, guns, and alcohol had been introduced. Thousands upon thousands upon thousands of text messages were sent by Ewer to her student and vice versa, referencing many sexual encounters, according to the prosecutors. And Miss Ewer introduced the teen to illegal and deadly drugs, including fentanyl, according to the district attorney's office. She also attempted to get the boy to bring a gun to their sexual encounters, as well as shoot a fellow faculty member at the school. Anyway, Miss Ewer told the boy to bring the gun to school and shoot another faculty member in the leg. Now, speaking at a hearing on January 31st, the boy's mother spoke of Ewer's painful betrayal of herself and her vulnerable son. Anyway, she said that Ewer had preyed on her son and led him to believe she genuinely cared about him, all the while exploiting him for money and manipulating him into thinking that he was the one. What makes this even worse, painful, is the defendant, the mother stated. Anyway, Ewers was sentenced to 4 years in prison on January 31st after pleading guilty last November to sexual assault on a child and contributing to delinquency of a minor. The felony plea was reached just a month before trial was scheduled to start. In exchange for a guilty plea, though, prosecutors dismissed 3 other felony counts and 1 misdemeanor. She faces at least 10 years of sexual offender probation, which would be a life sentence depending on her success with a sex offender treatment program. Anyway, when she gets out, she's going to have to do lifelong probation. And if you fail miserably, then it's an indeterminate life sentence here in the state of Colorado. Anyway, the Miss Ewers did ultimately apologize to the victim's family as she was before the judge, saying, "Hey, I'm really sorry, and I'm pretty sure this will never happen again." What can you do? I think somebody should have gone to crimetalksearch.com and tried to check people out. And remember, ladies and gentlemen, be careful. Be careful of people that are going to be near your children. Be careful. That's all I'm going to say right there. Next on the docket, this day in legal history. That's right, February 11th, 1794. The first public session of the United States Senate took place. That's right, it held its first open session, allowing the public to come and observe the proceedings. Obviously, that was a big move towards transparency, and it marked a significant development in the American governance system, promoting accountability and public engagement in the legitimate legislative process. And then on February 11th, 1812, the Massachusetts governor, Elbridge Gerry, signed an electoral redistricting law that favored his party. The practice became known as gerrymandering in reference to Gerry and the unusually, allegedly salamander-like district that resulted. Like I said, that goes back to 1812 that people have been trying to manipulate the boundaries for elections. Go figure. And finally, our dumb criminal of the day. Take a look at this body cam footage. Shows a man running from police down in Duval County, Florida. Jordan Evan Wilson gave up after he became a little too tired and laid down on the ground. And I love you can hear the police officer saying, "You're not going to get away. You're not going to get away. Go get that bad man." Anyway, Mr. Wilson was originally contacted for drug charges, arrested on drug charges, but he pled no contest to resisting an officer without violence to his person. He was sentenced to 2 days in jail with credit for time served. I think the video just speaks for itself. And then finally, ladies and gentlemen, that's right. We started this, I don't know, a couple months ago. I signed up years ago for this battle box thing. All right. And it's all kind of like outdoor survival type stuff. You know, I guess for the great apocalypse when it comes, whatever. Maybe the zombie apocalypse. Anyway, the new box has arrived today. So we will let you all find out exactly at the same time what is in the box. And I need to try to find out how we're opening this. Now, I'm going to open it, but I'm not going to let you see the blade because YouTube has weird rules about a weapon, and we don't want to get in trouble. So here we go. Can you hardly wait? The excitement, the anticipation. Oh, wow. It's a big one this time. All right. 10-year anniversary golden ticket. Scratch off a chance to win big. Ooh, I've got to see if we do that. All right, let's see what we got here. It's an Eco Kettle. Oh, it looks like you can boil water fast outdoor using natural fuel. Works in all weather. Oh, look at that. We'll take it, right? Looks like you can heat stuff up. It's got a little thing under there to cook, heat up the water. We got that. That's good. What's this? Fire spray, portable dry powder fire extinguisher. Ooh, can never have enough fire extinguishers around. You never know what's going to go around. Ooh, what's this? 2 fire sprays. Wow. Never have enough of that. Ooh, let's see here. We have a fire blanket. I guess our theme today is fire, isn't it? Fire blanket, preparedness fire blanket, extra large. Pull the blanket out with both hands, extinguish the fire, cover burning material completely, leaving it covered until it gets cold. Wrap the blanket around the person, burning clothes, etc. Look at that. Prepared hero. Now understand, this is not a promotion. I just get this and I just thought I'd share it with you all. Here are fire plugs, fire starters. Fire is definitely the theme here today. Here we have a lighter. A waterproof lighter. Look at that. See, definitely doing that. What do we have here? A modern Firecraft battle box. Oh, looks like another fire starter. Can't go wrong there. Oh, wait. Every month, because you get the big one. That's right. That's right. Another knife. Like we need another knife. We have more knives than we know what to do with at the CrimeTalk household and office here. Oh, that's a nice one. Look at that. Ooh, another nice one. Ooh. All right. That's all we have for today, ladies and gentlemen. Thanks for watching. Enjoy the show. I got to go out to CrimeTalk 1, assuming I can get out. It's snowing. We're going to play it by ear, but I have to be at a court appearance across the state, so we'll see how the evening goes, whether we go live or not tonight. All right. We're going to see if we won the golden ticket. Here we go. Only $10 off, but we'll take it. There we go. $10 off. Didn't win the big prize. $10 off, I guess. We'll take it. All right. Thanks for watching. We'll see you next time on CrimeTalk. And remember, the Constitution matters.